Good morning, Ms. Fitzpatrick. I think you're up first.
May it please the Court, Roberta Fitzpatrick for the appellant, Arbella Mutual Insurance Company. I have 3 brief points that I hope to reach today in explaining to the Court why the Court should vacate 2 discrete but significant rules contained within the new Massachusetts Automobile Insurance Plan because they violate the plan's enabling statute, Chapter 175, Section 113H. This Court has had the opportunity to pass on that statute in a variety of ways. Here we're looking at the main statutory objectives to be accomplished by the statute. The first we know is that the plan must ensure that insurance is available to virtually all applicants. The second objective is the objective we're focused on, which is that the residual market plan shall provide for the fair and equitable apportionment of the plan's premiums, losses, or expenses. And the key point is among insurance companies undertaking to issue motor vehicle liability policies in the Commonwealth. But that language is quite plain, and the legislature did not stop there.
But, I mean, clearly this is a statute that gives the commissioner a great deal of discretion in how to implement it. So there's don't you think that it's not inappropriate to come up with a plan that, in her view, accomplished that objective, but wasn't precise, that every company from the minute it started offering policies here was covered? I mean, you would give no discretion to the commissioner at all, it seems to me.
Not at all, Your Honor. In fact, that's point 2. Point 2 is Arbella acknowledges the breadth of the discretion of the commissioner, and it is quite broad whenever she is interpreting a statute which she's charged with complying. However, as the Court knows, the standard review is one of deference and not abdication, and when that discretion actually compromises a mandate, I would submit that this isn't even a question of whether it's rationally related or whether it's reasonably related. It's not even consonant with, nor is it consistent with the objective of the statute. Here it is an exemption. There is no allocation whatsoever. There is a formula that allocates the significant financial burden among all of the existing companies. At the time this occurred, there were 19. There are 9 new companies in the state in a year or so, according to the commissioner, and that's public record and on the website that you can take judicial notice of. But in any event, that means that a third of the market is not even part of the apportionment formula. We're not here asking you to look at the formula because the formula wasn't even applied. A decision was made out of the box to institutionalize an inequity in the plan.
What if we called it a lag as opposed to an exemption?
I think we can dress it up, and the commissioner has dressed it up as zero apportionment, lag, delay, partial exemption. No matter how you dress it up and what you call it, it is a plain and simple exemption. It is zero apportionment, which is exemption. Because they were never at the table. There was never even an opportunity to say, how do we apportion this?
Do the existing underwriters have to continue to write policies for people in the plan for 3 years after they decide to withdraw from writing insurance in Massachusetts?
They do. And in fact, as the risks are assigned, they must write them for 3 years. So an assigned risk policy that winds up in the assigned risk plan today is with Arbella for 3 years. And then the next company for 3 years and the next company for 3 years, while the new companies come in and have a complete free pass. No assigned risk policies, no losses. So I'd say that in the exercise of discretion, the commissioner appreciates, I think as you can recognize as the argument developed, that, gee, she really has to come up with a way to explain how this is apportionment. And if she could, then we probably wouldn't be here, except that she can't, because there was no apportionment.
Can I ask you, you say there was no apportionment. I take it there was an apportionment of expenses.
Expenses, by the way, Your Honor, are de minimis. We're talking about a deficit that has run in excess of $100 million.
I understand, but we're not talking about zero apportionment because the operation of the plan, or at least the expenses of that, were apportioned to all of the participating insurers, even if on day one.
Absolutely. Well, I will say this, that was the intention, and I'm glad you asked me that, because the notion that all that is required under this enabling statute and this statutory objective is to fairly and equitably apportion the expenses.
I'm not saying that's all that's required. I'm saying when you say that there was zero apportionment of anything, that's not exactly right. But let me ask you this. The argument is that prior to this rule, the existing rule had also provided some form of partial exemption for new entrants into the marketplace. Is that just simply not true, not correct?
I think it's the phrase that Arbella objects to, because partial exemption, we think, again, tries to disguise what is really happening here. I would describe it as an adjustment to the formula to account for market share, which is exactly what should happen.
Right,
but we don't even reach
explain
that.
that to me slower.
So-
Don't use those words.
So I would say it's not
What was it before?
Yeah.
Before, there was a determination made that companies have different market shares, and we're going to look at their market shares and then make adjustments within the formula to account for things that have happened historically. For example, there was a change where a lot of companies might have put a lot of business in the pool.
But we're talking about newly writing companies. I think that's the question.
Well, as to newly writing companies, the answer is quite clear. The day they came into this state and wrote the first policy, they had to share in the deficit based on their market share.
Did Arbella?
Well, when Arbella came, and that's a great example that they put in here, I think it's a mistake in proposition they suggest. Arbella took over another company's market share, Kemper, and properly was assigned that market share and then participated in the deficit based on that market share. So I don't really know what the point of the footnote was, because that's the way it should have worked. Now, had Arbella come in and taken over Kemper's market share under the commissioner's plan, even though it had, I don't want to give a number because I'm not sure how many participants there were in the company at the time, but it had many, many, many policies, it could have written scot-free with no losses. And
So your answer to Justice Cordy's question is that before, for a newly writing company, from day one, they would be treated just like a company that had been writing policies for 60 years.
And that's absolutely true. And if you read Safety's brief on that point, their amicus brief, it's set out there. Now, there was points in time where there were adjustments to the formula to take into account things like market share.
Well, how would this work? If a new company comes in, I take it the assignments are made on the basis of market share. Is that right?
Correct.
So they've been writing
for existing companies only.
For existing companies only. Well, a new company comes in. On what basis are they assigned cases for in the residual market based upon their market share?
Today, none, and that's why we're here, because the rule. What were they before?
No. Let me ask this a different way. What kind of regulation would satisfy you as to how new companies would be assigned residual or cases in the residual market from the day they first start writing?
Commonwealth Automobile Reinsurers proposed a rule, Rule 29. It's in the record. That is certainly what would.
What does that consist of?
What it said is that the companies essentially report their data quarterly, and then based on the quarterly data, assignments can be made. And that's the way it had been done and has been done and can be done. And it's quite easy. You just look at what Progressive, for example, that was here for the year, you look at their data for the first quarter, you say how large a market share do they have, how fast are they growing, and we better make sure, because the legislature required it, that we're fairly in allocating the burden. We never even got there because the commissioner decided that new entrants, for policy or political reasons that we say are outside the objective, not just outside, but conflict with the objective that all companies share among themselves fairly and equitably. If they want the privilege to write the good business, they've got to write the bad business. Here, we never reached that.
Ms. Fitzpatrick, would I be correct that boiled down, right? I don't know how many pages you wrote in your brief. I'm sure it complied with the rules, but you're simply saying that under Section 113HA, you are not challenging the fair and equitable apportionment. You're simply saying there was no apportionment.
I would say that's right. I do think that that's the kind of thing that is per se not fair and equitable, but this is true. We are challenging the fact that they did not apportion among companies undertaking to issue.
Would it follow that you are therefore not challenging the power, the authority, the delegation to the commissioner for her to determine what is fair and equitable? You are simply saying, I don't even get there because there's no apportionment.
Correct.
Okay.
Correct.
Now, going back to the world you'd like to see, after the first quarter, I assume then that you would have no allocation for the first quarter. So a new company comes in, they have zero market share, there's no data as to what their market share will be, it would be an exemption for at least the first quarter, correct?
I would say that that is what genuinely a delay is, but yes, that there would
So
be
you
no
s-
actual assigned risks at that
Okay,
point.
so there is some delay, and is this quarterly data come in on the first day of the second quarter, or does it take some time to gather?
I believe it's required at the end of the first quarter, and I'm not quite sure when the assignment is made.
So-
But
so-
then the assignments will quickly make sure that that party is brought up to where the other companies are.
Okay, so you would say during that second quarter, they would have an allocation that, this is a moving target, because you would think that a new entry would be increasing its market share over time.
And under the quota share formula, it's not really a moving target because you use the prior month's rolling average and you just keep adding on. It works perfectly well for the existing companies, and once you get new companies in there, it will be added to work for them. I see that my time is up. If I might just refer the court to a few parts of the record very briefly. I'd
Ms.
ask the court.
Fitzpatrick, you know
to
what
look
my
at-
rule is. The light blinks and you get to sit down.
Thank you very much for your
Thank you,
time.
Ms.
Your Honor.
Fitzpatrick. Mr. Litchland?
Good morning, members
Good
of the court.
morning.
My name is Dean Richland, and I represent the appellant, the Massachusetts Association of Insurance Agents, or MIA, as I will refer to it. Given my brief time, I'd like to move directly to an examination of the plain meaning of Chapter 162F and whether the takeout provision and the portion of that provision which is objectionable to MIA violates the statutory provision. The language of 162F appears at tab F of Maya's brief. I'd like to call your attention to the first sentence of that section, which provides that an independent agent or broker shall own or have an exclusive right to use. And then it goes on, certain insurance information that the producer gathers. And it's our position that those words have meaning. The first word, own, is clear. It describes the status of the interest that the producer has. It's an ownership interest. The second phrase regarding exclusive right to use, in our view, is somewhat redundant, but strengthens and emphasizes the element of
Mr.
the
Richland?
ownership interest.
When you look at that language vis-a-vis the writer of the policy, because it's talking about own and have an exclusive right to use certain information contained in insurance policy. So one would think that the company writing the policy has got to have some rights to that policy and the information that's on it, because it is a party to it. I mean, so I guess what I'm asking is, don't you need to read the first sentence with the second sentence to get the purpose of the first sentence?
Well, Your Honor, the answer to that question is no. I think these sentences are not, the second sentence is not limiting of the first. As to your first question, the answer is yes. The carrier, the writer, does have some interest in that information, but it is it's an interest that's subordinate to the ownership interest, and there's nothing in section.
There's something that just doesn't, that's counterintuitive, that the producer, that's a term of art, so the person that has physically printed this policy is a party to it, is ceding the total interest in the information that's contained in it.
Your Honor, I'm not suggesting that. What I'm suggesting is that their interest is subordinate, and certainly the law of property recognizes all kinds of interests that are subordinate to ownership interests. We would suggest that the statute makes clear that the primary holder of interest, the ownership interest, and the statute suggests no division of that interest. The primary holder of that interest is the producer. Further, that's consistent with industry practice, which was in effect at the time that 162F was adopted, which recognized that there was a change going on in the way that insurance policies were sold. And it talked about the rise of independent producers who this court has recognized serve a valuable purpose in serving as guides to consumers through the maze of various offerings, and recognized that in order to incentivize those individuals, they had to recognize certain rights in those individuals. And so I would suggest part and parcel of that is the ownership right that is now codified in 162F.
Excuse me, but isn't that ownership right as far as it relates to third parties. The third parties being the mortgage companies, the bank, the lending institutions, et cetera.
Your Honor, I would suggest a different read on this statute than the Commissioner suggests. The Commissioner...
That's what the Commissioner says.
That's right. And I would suggest that the second sentence is a specific situation that the legislature was concerned about and that we all know occurs in practical life, which is whenever we seek financing for something, the lending institution will often ask for proof of insurance. And in order to protect and encourage insurers to part with that information and to put it into the hands of financial institutions, the legislature thought it was important to provide a special protection. But the real order of who is the first party, second party, and third party, and not to sound a little bit like Abbott and Costello here, is that...
No, it's the Marx Brothers.
Well, we'll let history determine that one, Your Honor. But I would suggest that the second party that is unnamed in this statute is really the financial institution, and the third party is defined by what the feared use is. And the end of the sentence says, shall be prohibited from using, selling, or transferring such insurance information to any third party, here's the key words, for the purpose of marketing, underwriting, or soliciting insurance. Well, who are those third parties? They're carriers. They're people who could make use of this information for profit. And I would suggest that that language gives further strength to the idea that the legislature has recognized exactly what it says it's recognized: ownership and an exclusive right to use. And like lots of property, let's just take a ball that I take to the playing field. Well, that ball is best used when shared with others.
Okay, but help me to understand. Let's assume that, Mr. Richland, you are an agent for Arbella. And let's assume that for whatever reason, Arbella is very unhappy with the service you provided, and they say, we no longer wish to have you as our agent. What happens with regard to the policyholders who you brought in and referred to Arbella?
First of all, if there's a contractual relationship...
Right, there is. There was. And the contract
well,
has expired, and they say we don't want to renew it.
Well, then the contract controls. But if
okay,
the contract...
but what does that mean when you say the contract controls? I mean, I'm a policyholder through you. You said Arbella's the best deal for me. I've gone to Arbella, and now you have to say to me, I can't deliver you to Arbella anymore.
Right.
Is Arbella barred from speaking to me and saying, we wish to continue you as our insured?
Your Honor, what I'd suggest is that if the contract does not address what happens to the expiration under that circumstance, then I can make use of that information as the agent to seek other carriers for my customer.
Right.
I own that book of business. Now, I do face competition in the market as a
Okay, but how about Arbella? Is Arbella barred from writing me a letter to say, we wish to keep you as a client, but not if you remain with Mr. Richland?
I would suggest that the carrier who has the benefit of that expiration has some limitations on their ability to make use of that information.
Okay, but try my question. Can they write me a letter to say, we wish to keep you as a customer, but not with Mr. Richland, who we no longer deal with?
Your Honor, I can imagine circumstances when that would be perfectly permissible.
Okay, and isn't that then a use of the expiration date by the insurer?
Yes, but it's not a misuse of the information that's inconsistent with the ownership interests of the producer. Because under that circumstance, and let's just take the situation where I, as an agent, may have lost my license. If I lose my license, that's not a situation like the one that the regulation creates, where there's no indication that the producer's done anything adverse, and where there's no indication that the consumer's made any decision to de-designate that producer. It's solely by operation of the commissioner that this situation occurs, and we say that violates the
But here,
statute.
if I may, just for one moment,
Sure.
The insurance company is saying we're dealing in my example, we're dealing with Richland here only because this person's under the plan. He's not one of ours generally, and now we want to have this person be a voluntary policyholder. why are we stuck now with Richland, who we don't have a contract with, because we've moved from the plan where he was the agent and now he's a voluntary policyholder? Why must we be obliged to continue to deal with somebody who we don't wish to deal with?
Well, and it's exactly that situation for which Section 162F was written, precisely in the situation where the agent is unprotected by any contractual right. The legislatures recognize that if I develop this business, and indeed the commissioner wants me to develop this business for the MAPE, the commissioner has said that I am important and that I offer value. So if I do that, and if this court recognizes a public interest in me providing quality services, then there must be some incentive for me to do that. But if I have no right to hold on to the property interest when I have no contract, I say that situation is a direct violation of Chapter 162F.
Would I be correct in understanding that, in answer to Justice Gantz, when you said I can think of some situations, there have to be situations in which you, the agent, are disenabled for some reason, either because your license has been revoked or something that's personal to you, not because the insurer decides to move the business somewhere else?
That's exactly right, Your Honor. And evidence of that was that Carr had offered an amendment which addressed exactly those points.
Could I ask?
And Maya supported that.
Sure.
One question. You just, in answer to Justice Gantz, you said that 162F was written precisely for the situation that he mentioned, but 162D is no longer in effect. Is that right?
I'm unsure of that, Your Honor.
162D is the one that says that, at least I thought, said that that an independent agent would be paid pursuant to the plan established by the commissioner. I mean, in other words, when it was fixed and established rates.
Yes, that's correct, Your Honor.
Okay,
That's
so it's
right.
no longer in effect.
That's
right?
correct.
But at the time that it was in effect, when 162F was written in 1988, that would have, in this kind of situation, if there had been an assigned risk plan, at least as I read it, that would mean when the insured became a voluntary part of the voluntary coverage of the insurer, that the agent would still be entitled to to be compensated pursuant to the fixed and established rates. Is that not right? I guess I'm asking you, when you say it was written precisely for the situation, the fact is it was written long before the plan as we now know it was created.
Well, when I say precisely for the situation, I'm suggesting that it was written to speak in situations where there was no contractual relationship. And indeed, it's really with the advent of the new assigned risk plan that we have situations where there may be no contractual relationship between an assigned risk producer and an assigned risk company. And if the directive that I as an agent own something and have an exclusive right is going to mean anything, then it must mean that in that situation where there's no contractual right, I have some protection.
Thank you, Mr. Litchin.
Thank you.
Good morning, Mr. Barnico.
Good morning, and may it please the Court. My name is Thomas Barnico, and I'm Assistant Attorney General, and I represent the Commissioner of Insurance in this case. On the question raised by Arbella, the answer is that an apportionment has been ordered under the given rule. It's an apportionment, to be sure, for the newly writing companies that is initially related only to the calculation of expenses, but it is an apportionment nonetheless. And the Commissioner's decision on this is supported both by the plain language of the statute and also by the plain language of this Court's decision in Commerce.
But if I understand Attorney Fitzpatrick right, correctly, she seems to be saying that this is an improper exemption, and it's the way it's structured. There's 2 years given to every new entrant anytime a new entrant appears on the scene. Now, it may be very different if this delay were structured in such a way that, beginning January 1, 2010, and for a period of 2 years, we will not calculate what the market share is of anyone who is newly entering that the market share will be calculated on January 1, 2010, and then the next time it will be calculated will be January 1, 2012 for everybody. And then maybe a year later, so we're gradually going to phase it out. But the way it's written here is that every time a new entrant comes in, they're getting a 2-year, what she says is exemption. It's not a delay in the phasing in of the statute for purposes of the whole network, but it's specifically for one person.
I think that is her argument. I think that's fairly characterized. A couple of features deserve mention. Delay is a word that's proper here, too, at least in the sense that the assignments themselves don't take place for 2 years. It's an exemption in the sense that
the
resulting...
I don't mean to interrupt you. I'm sorry. The assignment of what doesn't take place?
The assignment of the risks who are declined coverage in the voluntary market and therefore have to go to the residual market. So I agree with the proposition that I don't think the characterization is crucial in that respect. Exemption, I think, is a word she uses to dramatize the degree of the break for the newly writing companies.
You're saying there's a rational basis for this exemption.
Right, and the standard
But there's
here...
a rational basis for the exemption, because I think even she would concede that for a quarter, right?
That's what I heard, yeah.
Yes, but so then I'm saying, what is there to suggest that a 2-year, quote, exemption or, quote, delay is reasonable?
Well, I guess that's again, a matter of degree. In the statute, the support is the words, or any combination thereof. That's an exceedingly broad charge to the
I understand
commissioner.
that.
Right. And
So you
2 years is just a decision
How about
based...
10 years?
I don't think 10 years has the same parallel nationwide, the 2 years.
Do you have any authority to support the fact that 2 years would be reasonable?
Only by analogy to the operation of similar plans all around the country.
And do they have the same language? I was going to ask you that. Do they have the same language in their statutes?
That I don't know. I don't know as to the particular issue here as to exemption. Certainly some of the statutes support the adoption of the MAPE in the first instance. But so there's no particular reference that would give you 2 years as the mandated statutory formula. It's simply a judgment call by the commissioner in her discretion to decide that that would be the type of break of sufficient degree that would encourage new entrants to the market.
Are there any statistics that back up the fact that 2 years is necessary as opposed to 1 year or 6 months?
No, not statistics. I don't think are in the record in that respect.
Do any other states have a 2-year delay period?
Yes, and that is in the record because the insurers who supported this particular portion of the rules included in the record that is before you a good amount of information about what goes on in other states. This is a useful contrast as well, and that is because unlike some other states or many other states, Massachusetts will calculate the assignments for the new entrants after the 24-month delay on the basis of the prior 12 months' writings. They won't go back to use the very low numbers.
They won't do a rolling average from 0 to 2.
So no, but by calculating and using that 12, that will bring them in a quicker way up to the market share, which the Arbella insists is required as a matter of law under 113H.
The assumption being that when you come into the market, there's always a slow entrance.
Right. And that is a key assumption.
How
here.
often is market share reallocated? That is, if Arbella were to do a media blitz and increase its market share in one quarter from 20% to 40%, would it be changed for the next quarter, or would there be a delay?
I'm not sure that's the case, Your Honor. I think the reporting that she was referring to may be quarterly, but many of these, I don't know for sure here, but many of it's an annual assessment or
Well, I mean,
calculation.
it matters a little bit to me as to if Arbella is subject to a quarterly reallocation, the question should be, then why shouldn't a new entrant? If Arbella is subject to an annual reallocation, then it'll be a different situation for a new entrant.
Well, the answer to that, I think, Arbella's history provides good facts on that, and that is it's rational to treat someone who is not taking over a book of business differently than someone who is truly a new entrant.
No, I don't mean to be focusing on Arbella as a new entrant. I mean to say that it matters to me how quickly the reallocation occurs with regard to existing companies, and I guess you don't know.
Right. No, no, and, but I think, again, it's a judgment that 2 years is a reasonable position to take if your goal is to encourage new entrants. Now, as to the history of previous breaks, our position is not that the 2 year is identical to what has been provided the newly writing companies in the past. I think the best source of the Gailey report, which is mentioned in the briefs, I think has more of the history of what exactly the break would have been. I'm sure that it was
When you're
more
using
of a,
break, are you talking about an advantage?
that's right, for
Yes.
the newly writing, and it was, I think it took the form of a percentage reduction in the amount of the car deficit they would have otherwise had if
Now,
you went.
Arbella says that the commissioner's not entitled to give breaks unless the company is, as a matter of statute, sufficiently in trouble that she has the discretion. Are you saying then that that she can give breaks to a company if she thinks the company, for whatever reason, warrants a break?
Well, perhaps as a class, that's certainly true. I think this is really never is rarely or never been done on a company-by-company basis, except in terms of there's a reference to when the solvency of the company is at stake under 113H. But otherwise, this is exceedingly broad standard of a fair and equitable apportionment or any combination thereof. This would fit very comfortably in that language. And I have to remind the Court, what it said in Commerce was that 113H does not specify how the apportionment must take place. Elsewhere, the decision says in what's very broad language that this language that we're talking about fair and equitable apportionment, is not descriptive of any particular model, but only of the constitutional ramifications that might arise if you hypothesize some very extreme apportionment which denied to the company a fair opportunity to achieve a reasonable return on investment.
Are you going so far as to say that if the commissioner had said, listen, we want to encourage them to be hiring those who are indigent or who were once on public assistance, and any company which is going to hire 10% of its people for public assistance, I will then give it a break and not require it to be allocated any persons from the pool for a period of a year in order to encourage that good behavior. Can she do that?
Well, maybe not, because she is bound by the rational relation to the terms and purposes of 113H. I don't think the Court, when it said that in Commerce, meant it could go beyond the usual test of a rational relation to the terms and purposes of the statute. So I think that there is some limit in that respect, but within the bounds we're talking about, the Court's already said that there's wide discretion here, as Justice Botsford started the argument today with a point.
Could I just ask you this to go back to your history, and I know you need to get to your other point, but with respect to the old system with the car operating and the facility, I take it that in a series of that the relationship between the statutes that you talk about, the previous statutes where you say the legislature recognized the commissioner had sort of come up with formulas under this apportionment part.
Right.
So what is the order of those things, that the commissioner by regulation or rule would do something, and then you're saying, and then the legislature sort of recognized that that was okay? Is that?
Yes, it's a ratification argument. That is exactly the chronology. Breaks, as the word I'm using for newly writing companies, existed in the mid-'80s. 1988 comes along. Arbella is formed by the Enabling Act, and in that Enabling Act there is a specific reference to the existing breaks for newly writing companies and denies them to Arbella because they are seen as already achieving a certain market share by taking over the Kemper policies. So, so in that sense, the reference made by Arbella's counsel, I think, is helpful to our position. That explains why someone like Arbella wasn't receiving those breaks at the time. And unlike some ratification arguments, where we're arguing to the court that the mere legislative acquiescence in an executive practice is tantamount to ratification, here we have the much less common situation where the legislature actually identifies in the 1988 statute a practice of the executive under 113H. So we think that that bit of history further supports the Commissioner's decision in this case. I have to...
Mr. Barnacle, you want to turn to the agents?
I do. I want to turn first to 162F because we have our own plain language argument. We think this refers to the information in the hands of the agents. That's why there is in 162F the phrase embodying the records of an insurance agency. Our argument that this can't foreclose the writing of a voluntary policy by the company assigned to the policyholder under the MAPE does not drain away from the agents all the protections under 162F. The two protections remain. They have those ownership rights. They will be recognized in matters of business transactions like sales, mergers, perhaps common law claims about misappropriation.
How? How? I mean, so...
Well, that's where the precedent they do cite, I think, is useful. The Dart case recognizes that in a bankruptcy setting, for example, their book of business, the information they hold is an asset.
You've got an agent who hasn't lost his or her license, hasn't moved out of state, is still, able to and does participate as an agent in Massachusetts, and policy comes to the end. The only reason why that policyholder was identified was through the work of the agent, correct?
Only in some cases.
But take that case, right? With some of these policies,
it's possible,
and ended up with whatever insurer does, and then at the end of that, the insurer says, "Don't want you to use that agent, but want to continue to cover you." Seems a little harsh.
Well, competition sometimes results in lost business. What's going to be at a competitive is the writing of the new voluntary policy by a company for that person who has been in the assigned risk pool. And just as the assigned risk carrier that's been matched with that policyholder for the period within the 3 years can take that risk out and write it voluntarily, so too any direct writer who happens to become aware of policyholders who may wish a change, who may want a voluntary policy, these direct writers have the opportunity in a competitive market to contract with the policyholder.
Do they know when the policy is about to expire?
They may or may not.
Well, let me put it this way. I've just bought my insurance for my automobile or whatever it is, and I start getting this junk mail saying you really should come and insure with us, and I've just paid a year's, I'm going to toss it in the waste paper basket. If it comes on about the 11th month in 10 days, I'm getting two pieces of mail, one from the agent saying it's time for you to re-up, and then somebody said, well, you actually don't have to go through the agent. We can do it better this way.
That's right.
I'm focused.
Right. The same information could be, though, obtained easily in a survey. Some people are more willing to speak on the phone than others, and this is...
Not from me, Mr. Barney.
This is... Well, I can agree. We can agree on that. But that proves an important point, and that is, in the first instance, this is information, the real ownership of this information is in the policyholder's hands.
No, but the agent is sitting on the information.
And
you are, the insurer.
Yeah. But in these circumstances, I think the statute should be read to, not read to direct itself to the policyholder and the carrier. That's really the point, and you know that from our brief, that it recognizes ownership rights, and it specifically enumerates those third parties against whom the producers maintain rights. Thank you very much.
Thank you, Mr. Barnicoat. We'll take a short break.